We're going to dive right into today's topic, and the topic is using PTO, personal time off, or vacation time for workers' compensation. I think that is one of the biggest questions that a lot of people get, or misunderstanding that they can also have. So I wanted to give you the platform, Bilal, so that you can guide us a little bit as to PTO and vacation time for workers' compensation.
Sure. So when you're looking at in sick time and vacation time, there's a lot that goes into it. There's a lot of moving parts and questions to address when you're talking about those two subjects in particular. I think the big concern comes from people who are initially injured at work and they're not receiving work comp benefits. And so their employer is likely to tell them, hey, because you're on work comp, but you're not receiving benefits, what are you going to do, right? How are you going to get paid? Because we're not going to pay you unless you have vacation or sick time booked. The second part to that then is what happens if you burn through your sick time or vacation time and you have no time left. So starting from the beginning, obviously, you report a work injury, the insurance company may deny your case or they may accept it. Usually it's accepting it to some extent, but oftentimes they're still denying the case. And when the case is denied, that means the insurance carrier is not going to pay you temporary disability, which is normally the benefit you receive if your doctor has you off of work for an injury. So you're going to go to your employer and you're going to have a work note from your doctor that says you need to be off work, but you're not going to receive money unless you go through vacation time or sick time. California in particular, and most employers in other states actually have policies that are legislated in that provides for mandated sick time. So there is some level of minimum sick days available, but oftentimes that's not a lot for people. Sick time, I think, caps out in Oakland, specific to us, at 9 days per year, which if you're recovering from a pretty significant injury isn't a whole heck of a lot of time for you.
Right.
So then the question is, what do you do after that? And a lot of times people are being told by their employer that, hey, you have to dip into your vacation time in order to receive money while you're off of work if the insurance carrier is not paying you. So a lot of people are reluctant to do that just because vacation time, especially if it's accrued vacation time with no potential cap on it, could be a lot of time that you've accumulated as a job over the years that you don't necessarily want to burn through for a work comp injury that should be covered by the insurance carrier. So in some instances, yes, you can be told that you have to use your vacation time and sick time. The issue that's kind of beside that is your job protected while you're off of work?
Right.
So in California, most employment is at will, which essentially means that your employer can let you go for any number of lawful reasons. Obviously, it can't be discriminatory, but if the employer needs to reduce its staff, like we've seen recently with the COVID epidemic, or if business isn't doing well and so they have to lay off some staff, or maybe they've eliminated your position due to having other staffing needs, whatever the case may be, they can let you go. And so oftentimes people are concerned that if they're out and they don't have accrued time, that the employer can then terminate them, which is technically true. So a lot of people actually need to apply for FMLA leave potentially. FMLA leave is something separate than the right to benefits under workers' compensation, in the sense that FMLA leave is a classified status which protects an employee's job for up to 12 weeks in a 12-month period of time while they're out.
Which
so
is
if the employee is concerned
for women when they're pregnant, the Family Medical Leave Act, right? That you actually get the 12
exactly
weeks, potentially helping you not to lose your job if you need to be out for that amount of time. I have a quick question for you, Bilal. You mentioned
Sure.
that when you're starting the process, when you're going through it, the insurance has to either deny or accept your claim. What is the time frame of you waiting, and when do you make the decision of using your PTO and vacation time if need be?
Sure. So when you report the claim, it triggers the insurance company's essentially their responsibility to investigate the case. Oftentimes it's pretty obvious when someone has a legitimate injury. If they saw their arm off or something, or they're sent to the hospital via helicopter, it's obvious. It happened. It's witnessed. There's a lot of people around. The injury is serious. It's clear. Other times when an injury is reported, maybe a few weeks after it actually occurred or a few days, the insurance company is much more likely to investigate the case. And they have up to 90 days from the time they have knowledge of the case, or should have had knowledge of the case, to do their due diligence to determine whether or not they want to accept liability. When the case is in delayed status, the insurance company still has responsibility to provide treatment up to $10,000. they do not have an obligation during that time period to pay temporary disability benefits if you're off of work. So all that being said, if someone is in a delayed status or their case is denied, in terms of just the pay itself, they can take SDI. That's what they would apply for through the Employment Development Department, which is state disability insurance. It's normally there to pay for non-industrial issues, but they'll also pay if a case is denied. So the state disability will typically pay a little bit less than temporary disability just based on their formulas. It's probably around 55% of your average weekly pay based on your previous 4 quarters of earnings versus temporary disability, which is more along the lines of 67% of your average weekly wage, kind of evaluated based on your 52 weeks of earnings leading up to your date of injury is typically how it's done. There's obviously exceptions to that. But again, when you're looking at temporary disability and state disability, you're not necessarily talking about one's employment status. Your right to benefits and your employment status are kind of 2 different things in some instances. A lot of people think that just because they're off of work because of an injury, that they can't be laid off or terminated. That's not necessarily true, although it's not a smart move for the employer to terminate anyone while they're off on workers' comp, just because it's kind of a prima facie evidence that they're actually terminating them because of a disability, which is something that's protected under the California Fair Employment Housing Act, as well as the federal law, which is the Americans with Disability Act. But if someone's forced to use their time, if it's accrued time, which means it's their money, it's something that they've earned in their paychecks, like vacation time, and they have burned through vacation time while they're recovering from an injury, we can actually go back and sometimes negotiate either, a reimbursement of their vacation time, which means it goes back in their accrued bank, or if they were using vacation time and the insurance carrier should have been paying temporary disability while the case was denied, the insurance carrier does not get credit for the fact that they received their vacation pay during that time. The insurance carrier would still have an obligation to pay temporary disability. So in some sense, they are getting their money back, but the vacation time would be kind of gone from their account. It would be used, but to some extent, they're being reimbursed for it. So it's not like they're getting nothing and had to use their money. You're just kind of front loading it. But when it comes to self-insured entities, you see it a lot with school districts and municipalities. We've actually been able to negotiate, unaccrued time off and other benefits as part of a package deal with the settlement. It's really kind of a case-by-case basis. But oftentimes, the employee is going to be told they need to use their vacation time or sick time unless their job status is protected. And it can be very difficult. And so oftentimes if someone feels as though their employer's, pressuring them and are acting in a discriminatory manner, we do ask that, you keep a little diary, keep logs of when you talk to people, what their name is, what they said, if to the extent possible, when you're communicating with HR or your boss, your supervisor, make sure you're doing it in writing via email. That way you have a paper trail. You'd be surprised how often employees are told one thing in person and then in writing it's something else. And that's because the employer knows they're doing something wrong and they just don't want to document it.
Right. So then you would say that necessarily you don't have to use your PTO. You don't have to use your vacation time. What if an employee decides, you know what, my boss is trying to make me use this to accommodate for the time that I'm going to be out and I still get paid. But what if I refuse to, like, you know what, I want to keep it in the bank and I'll just deal with it as it goes? That is an option they can also take as well, right?
Correct. I mean, you're when it comes to vacation time, especially, it's an accrued benefit. It's your money. If you were to leave a company and you have accrued vacation time, the company would have to pay you out for it if you don't use it. And so the company can't require you to take vacation time. The caveat to that being is the company also doesn't have to give you extended leave unpaid forever and ever. And so it's a delicate balance where the employer will often tell the employee, in order to ensure that you don't lose your job, you have to use vacation time or sick time. And then the employee, of course, feels pressure to use it. But again, that kind of goes back to FMLA leave and their protected status and whether or not they're covered at the time that they're being told that. Because you'll often see it with school districts. They'll have this 39-month rehire list where essentially the school district will keep the teacher or the staff, whomever it is, on hold which makes them eligible to just go back whenever for up to 39 months following their initial leave. Now, if they exceed that time, they'll be put on a rehire list, which essentially means they're still eligible for rehire, but they don't have a secured job waiting for them anymore. And there's a lot of times where, clients will say, hey, my boss told me they couldn't accommodate my work restrictions and that they were laying me off. And so a lot of times it comes down to the business necessity as well. A smaller mom and pop shop with, a very limited budget and staffing needs, that they need someone there to fill the job, and they will rehire someone and unfortunately lay the employee off. If it's a bigger company with a bigger budget, more resources, the less likely it is they have a legitimate reason to lay someone off or terminate the employment relationship just because they're out on leave. But again, it's the employer's burden to essentially show that they had a non-discriminatory reason for terminating someone or letting them go. So, I do caution people when it comes to using vacation time. Your employer can't force you to use it, but you also have to be mindful of your employment status as a separate issue and whether or not your job's actually protected under FMLA leave or otherwise.
Right. That's exactly what I was going to ask you right now. Are there some precautions that they can take, as far as taking it? And you just answered that question. So I think that, it's very important to, like you said, it's case by case. If you have any questions, reach out. We do free consultations here at Pacific Workers Compensation Law Center. We can be reached via Facebook. You can find us on Yelp. You can find us on Google. You can look us up on pacificworkers.com. And everything is done virtually from the comfort of your home. You can do some sort of Zoom meeting, which is kind of like what Bilal and I are using to record this. And I think the most important thing someone can do if they have questions is just ask someone who knows about it and not just go play by ear. Because I think a lot of the times what happens is, say my coworker also got injured and he had a certain circumstance and he'll tell me his experience, and I feel like that's going to be my experience as well. So like you mentioned, cases are completely different.
Yeah, and everyone's got a friend's, neighbor's, cousin, sister's, brother, right, who had a work comp injury and they went through this whole ordeal, and X, Y, and Z happened to them. And really every case is different, and there's a lot that goes on behind the scenes in these cases that maybe weren't talked about in casual conversation. And so, anyone who has questions about their case specifically, I do recommend they consult with an attorney. Our office in particular does free consultations. So if you have any questions or concerns about an ongoing case for yourself, or you want to refer a friend or family member to us for help, we're more than happy to talk to them and give them some, at least, some basic advice and recommendations on where their case should go. But don't listen to your neighbor. Talk to a professional, get all the info. There's a lot, again, and most of it's not easy to understand. And so it makes sense to talk to a professional about it.
Right. And there's also plenty of blogs out there. So I know, for example, we have tons of information on our blogs featured on our website, pacificworkers.com. But it's also very important to actually know where the source is coming from. I recently bumped into a Facebook group where people ask questions in regard to what's going on as far as them getting injured at work. And hey, any suggestions can come in from, it could be either other injured people, or it could be other attorneys, but it also varies state by state. This information that you were given is for the state of California. I'm assuming other states have other type of information. So it's very important to look where you're getting the information from. And like we said, don't just because your coworker did the same thing doesn't mean you're going to get the same thing. So do your homework, talk to an expert. You can definitely reach out to us. Bilal, thank you so much for your time. I know you have to get going, and we hope you guys can join this, share this with anyone you know on your Facebook, and we're here for you guys. So thank you guys and have a good day.
All right. Thank you.